In a 4:1 majority ruling, a constitution bench of the Supreme Court headed by Chief Justice of India D.Y. Chandrachud today upheld the constitutional validity of Section 6A of the Citizenship Act, which grants citizenship to immigrants who entered Assam between January 1st, 1966 and March 25th, 1971. While Justice Surya Kant authored the lead majority verdict on behalf of himself, Justice M.M. Sundresh and Justice Manoj Misra, the Chief Justice penned a concurring opinion. However, Justice J.B. Pardiwala rendered a dissenting opinion declaring the statutory provision to be unconstitutional but with a prospective effect. But before we dive into the nuances of this particular verdict, let us first understand what Section 6A of the Citizenship Act exactly stipulates and how it came into existence in the first place. Section 6A is a special provision which was inserted into the Citizenship Act in furtherance of a Memorandum of Settlement called the Assam Accord, signed on August 15, 1985 by the then Rajiv Gandhi government at the centre and the All Assam Students Union, following a 6-year-long agitation against the entry of migrants from Bangladesh into Assam. Assam has long faced challenges with the illegal entry of immigrants from East Pakistan and Bangladesh due to the porous terrain of its border, which is characterized by numerous streams and rivers. A key feature of the Assam Accord was to identify who these foreigners were within the state. Clause 5 of the Accord set January 1st, 1966 as the base cutoff date for the detection and removal of these foreigners. However, it also allowed for the grant of citizenship to immigrants who arrived in Assam after this date, that is up to March 24th, 1971. Section 6A was incorporated into the Citizenship Act to fulfill this particular objective. The provision states that all persons of Indian origin who entered the state before January 1st, 1966 and have been ordinarily resident in Assam ever since shall be deemed to be citizens of India. It also provides that individuals who entered and resided in Assam after January 1st, 1966 but before March 24th, 1971 and have been detected to be a foreigner by entities such as the Foreigners Tribunals would have an opportunity to formally register themselves in compliance with the rules framed by the Union government. Following such registration, they would be entitled to all rights as enjoyed by any other citizen in the country, except that they would not be entitled to be included in the electoral rolls for voting for a limited period of 10 years. Now, why was this provision exactly challenged and what were the arguments advanced? During the proceedings, the petitioners had argued that the cutoff date in Section 6A is discriminatory since it prescribes for a different standard for grant of citizenship to immigrants who have entered Assam compared to the rest of the country. In contrast, the centre had argued that Article 11 of the Constitution confers power upon the Parliament to enact any law for the acquisition and the termination of citizenship. Notably, Solicitor General Tushar Mehta, appearing for the centre, had blamed the policies followed by the West Bengal government for creating a hurdle in the timely completion of fencing the Indo-Bangladesh border to prevent infiltrators and illegal immigrants. Other respondents, including the NGO Citizens for Justice and Peace, had defended the provision, arguing that striking it down would render hundreds of residents stateless after over 50 years. Now let's look at some of the key observations in the verdict. Upholding the constitutional validity of Section 6A, Chief Justice D.Y. Chandrachud underscored that this particular statutory provision balances the humanitarian needs of migrants of Indian origin and the economic and cultural impact of such migration on Indian states. He also asserted that the mere presence of different ethnic groups in a state does not automatically result in a violation of Article 29, Subclause 1 of the Constitution, which guarantees the protection of interests of minorities. Instead, he pointed out that it has to be shown that a particular ethnic community is unable to take steps to protect its culture or language due to the presence of different groups, which according to the Chief Justice, the petitioners in this case failed to show. Concurring with this, Justice Kant in his opinion underscored that Section 6A embodies the principle of fraternity. He wrote in his opinion, and I quote, "Our reading of the Constitution and precedents is that fraternity requires people of different backgrounds and social circumstances to live and let live. The nomenclature of fraternity itself is self-explanatory to the extent that it exhibits the notion of inclusiveness and togetherness as opposed to restricted applicability. Thus, it becomes imperative to refrain from employing this concept in a negative manner that selectively applies it to a particular segment while labeling another faction as illegal immigrants solely based on the alleged unconstitutionality of Section 6A. Justice Kant further observed that accepting the claims of the petitioners would result in opening the floodgates to similar challenges by residents of other states who might want to attack such interstate migration under the guise of protecting their indigenous culture. He, however, acknowledged that at this stage of proceedings, the court is not equipped to embark on a microscopic fact-finding exercise to determine whether there has been any cultural erosion as claimed by the petitioners. On the other hand, Justice Pardiwala in his dissent opined that Section 6A, although may have been valid at the time of its enactment, it has attained unconstitutionality with the passage of time since it has failed to be proven effective to address the problem for which it was adopted in the first place. He noted that this particular provision, by not setting any particular temporal limit to its applicability, further promotes the immigration of illegal immigrants into Assam and is thus liable to be struck down. He observed in his dissent, and I quote, "While the object that was sought to be achieved long back with the aid of the enactment of Section 6A of the Citizenship Act remained a distant dream, its misuse has only continued to increase with the efflux of time. I say so because with the passage of time, the government records would get damaged and perish, making it increasingly difficult to cross-check the false claims that may be made by the immigrants of the post-1971 stream." The judge also pointed out that the adoption of Section 6A by the then government was not merely to grant citizenship but was also to appease Assamese people ahead of the upcoming state elections at that point of time. Today's Supreme Court ruling is said to have a significant bearing on the contentious NRC exercise in Assam, that is the National Register of Citizens. The dates set in Section 6A form the basis for the final NRC prepared in 2019. Although the NRC has been in limbo for the past 5 years, the ruling today upholds the basis on which it was prepared. Thank you for watching. For more such videos, please subscribe to The Hindu.